So my name is Vicki Bowles and I'm a senior associate here at BWB. I work primarily in our commercial team, but that's just sort of where I sit. My specialism, for those of you that don't know me, is anything information law related. So data protection, obviously, but also FOI, the environmental regulations, privacy, confidentiality, all of those kinds of issues. Today we're just talking about data protection, and I work for all of our clients. So I don't just work for commercial organisations, I work for charities, I work for schools, I work in healthcare, I work in pharma. And the great thing about data protection is that the rules generally apply the same, whatever type of organisation you are. So it's easy for me to skip between, I say it's easy, I can skip between a university and a grant giving charity, and then tomorrow I'll be dealing with a software company, but then the rules generally are the same, which is quite helpful. So today I'm going to cover a few discrete areas. I'm going to look at privacy notices, a few bits around subject access requests, a bit about data breaches, and a bit about contracts. And I've picked those particular areas because they are the areas that in the past sort of 6 to 9 months, I'm getting the most kind of questions about from my charity clients. So I figure those are the kind of areas that are coming up. So they should be the ones that hopefully are nice and topical and nice and helpful. And then we shouldn't have to touch on anything related to Brexit or anything particularly COVID related today. So that might be a relief for some of you. So privacy notices. For those of you that don't know, the term privacy notice essentially refers to the information that you are required to tell individuals about what you are doing with their data. And we call them privacy notices because that's how most people comply. So they will have you will have seen privacy notices, you will have privacy notices, you'll know what a privacy notice looks like. It doesn't actually have to be a document, and it's not a requirement to have a privacy notice. The requirement is to tell people what you're doing with their data, and there are certain things, I'll talk about those in a minute, that you have to tell people. Usually the most convenient way of telling them is in a privacy notice, but actually it doesn't have to be a document. You can do it in whatever way you want. And I've seen some really interesting and clever videos actually on other charities' websites where they've got vulnerable beneficiaries or beneficiaries that aren't going to understand or want to read a 7-page technical document. So they've done a video explaining different bits and pieces, and that's perfectly acceptable. The requirement is to give the information. How you present it is totally up to you. So although I'm talking about privacy notices, please remember it doesn't have to be a notice. So why are they important? Well, first of all, it's a legal requirement to give this information. So you are required to provide it. And if you don't have one, you are obviously in breach of that requirement, but you're also in breach of the first data protection principle, which says that anytime you deal with personal data, so anytime you do anything with it, it must be fair, it must be transparent, and you must have a legal basis. And it can't be transparent if you haven't told the individual what you're about to do with their information. So that's why they're important for 2 reasons. Also, in terms of your privacy notice and how well it's drafted, how much information it contains, if it doesn't contain everything you need, you may end up needing to send out lots of mini privacy notices as you evolve and as new things arise, and that can be problematic. So I have seen 2 instances of this in the last 6 months. I've had one charity and one school thinking about a merger, and they're going through the due diligence process. So as part of that process, they are providing the other organisation with personal data. Now, the possibility of merger was not mentioned in either organisation's privacy notice. So they hadn't told their staff and their pupils or their beneficiaries or whoever it was that their information may be sent to another organisation for the purposes of a merger. Therefore, in providing that information, they were in breach of the requirement to be transparent about what they were doing. Now, the problem with that is the simplest way to resolve that is just to tell people and say, well, okay, we're now using your data for this purpose. And that's not necessarily problematic, but in the case of a merger, it can be, because you may not want the details of the merger to be made public. It may be highly confidential, it may be sensitive, and you don't want the general public getting hold of it. So you don't want to be amending your privacy notices or releasing new ones, which will then tip people off. So that's why it's important to think about not just about the core of what you're doing today with data, but also what might you be doing with data in the future and what might crop up. The other reason they're important is that complainants use them, and I see this all the time. And it's not something that's going to get you a fine. So if you've got somebody who's making a complaint, even if it's not related to data protection, to be honest, any kind of complaint, we quite often see complainants looking at a privacy notice, finding a deficiency, and then adding that to their list of demands or complaints that they've got. And obviously the problem with it's not something, as I say, that's going to get you a fine if the ICO comes across it. They will just tell you to update your privacy notice and make it clearer, or whatever the issue is. But it's just another thing that you have to deal with, and it's time consuming, and you have to look at the complaint, you have to look at your privacy notice, you have to go through. If you've got a privacy notice that you know is pretty much there and has everything it needs, it just stops complainants adding that and you having to take the time to then deal with those complaints, hopefully. So what makes a good privacy notice? A good privacy notice is clear. It uses plain language. It's aimed at the individual and it's relevant. So not, of course, with any of my clients, but we do see standard templates being used that people have just cut and paste their name at the top, and actually it doesn't really relate to their business, and it's talking about things that they don't do, and perhaps it's missed a few things that they do, and all of those things. So that's not helpful. And I talked earlier about looking at videos and different ways of presenting the information, and that's the aimed at the individual bit, really. So who is reading this? Is it going to be a data protection lawyer who knows exactly what they're expecting to see, in which case you can make it as technical as you like? Or is it going to be a 15-year-old vulnerable beneficiary who may not have great reading and writing skills, who may need to have it explained to them? So who's it aimed at, and that will help you decide how you present the information. I'm not going to go through the next two slides in detail, but obviously when you receive a copy of the slides, you will then have a list of all the things that the privacy notice needs to contain. Now, as I said, this is the legal requirement, so you're required to give all of this information. But you don't have to give it all in one go. You don't have to give it all in a written form. As long as you can demonstrate that you provide the information, that's fine. So in a lot of cases, particularly with charities, and particularly where you've got vulnerable or younger beneficiaries, talking this through is absolutely fine. Just make sure you keep a note of what the individual's been told, what you've told that beneficiary. Perhaps one of the ways you can do that is to have a bullet point list, so that the person who's delivering the information knows what they've got to cover. They can tick it off when they've done it. That's a simple way of doing it, or keeping a note, or however you want to do it. Again, it's totally up to you how you do it, as long as you provide this information. And it's on two slides because there's a lot of it. I've taken that from the ICO website as well, so it is out there and available for you to look at. So if you're looking at your privacy notice, you think, okay, well, I'm going to go away and I'm going to check what we've got and have a look and make sure we're covering everything. How do you make a start with that? Well, the first thing I would do is not look at the privacy notice. I would sit down and I would think, okay, what are we actually doing with personal data, personal information? Why do we need it? So what are we using it for? What information do we need for the purposes that we've identified? And then you can link your legal basis to the purpose for which you use it. So a common mistake that I see quite a lot in privacy notices is around staff. So generally, the legal basis for processing your staff information will be contract, because you have a contract with them and you are fulfilling those contractual obligations when you deal with their personal data. What a lot of organisations will put is consent or legitimate interests. Now, legitimate interest is fine. You can use that, but actually you are relying on contract, and that's a much easier and simpler legal basis to choose, because you don't have to balance then the rights of the individual against your legitimate interests or their legitimate interests in being paid or whatever it is. So it's helpful to get that legal basis right. Consent isn't right for employees because of the imbalance of power. So consent, as I'm sure you're all aware, has to be freely given and informed and all of those other things. But if you're in a situation where there is an imbalance of power, it's very difficult for you as an organisation to show that an employee has freely consented to you having their information for the purposes of the job, because actually if they don't give you that information, they're not going to get paid or they're not going to get employed or whatever the consequences are. So it is important to look through. Another thing we saw mainly when the GDPR came in, I haven't seen it so much since. I think people have sort of got to grips with that, is everyone was just trying to use consent, and actually consent should really be a last resort, because it has to be informed and it has to be freely given, and you've got to keep a record of it and all of those things, and people have to have the right to withdraw. So you have to think about, is this, if you're going to use consent, is this a genuine choice? Or actually, if they don't consent, can they not use the service, or can we not provide the assistance that we're going to provide, or whatever it is? So that would be your starting point. And then the other tip I have is to, as I mentioned before, think about the other things that you might do. So you might at some point need to get legal or accountancy advice, and that may involve the transfer of personal data. You may merge with another organisation, as I mentioned. You might be asked for information from the Charity Commission, or you might have to provide information to the Charity Commission. You might have to provide information to the Information Commissioner's Office if you're the subject of a data breach. So it's worth thinking through those non-day-to-day things that might crop up in the next year, 2 years, 5 years, that you know might be on the cards or possibility. With the merger thing, even if you think it's highly unlikely, we would always recommend popping it in there just in case, because as we know over the last 18 months, the world can change, and things can change rapidly, and we may be in a completely different place in a year's time from now. So it's always worth planning for those eventualities. So that was all I was going to say on privacy notices for today, at least. You may have guessed that I'm quite passionate about privacy notices. I do think they're important, and I do think that they are helpful to get them right. So I appreciate that they're complicated, and they can be quite pricey if you get our advice and we try and draft something very bespoke for you, and they are a pain to do. I do appreciate that, but if you get them right, then that saves you a lot of work down the line. So that's why I really encourage my clients to get it right now, and then I'm not having to advise you on a complaint and also updating your privacy notice at the same time. We can just deal with the complaint and not have to deal with that. So moving on to subject access requests, I'm sure, because we've got quite a variety of people on the call, that some of you will have had hundreds of subject access requests, and some of you lucky people may have had none. And there seems to be very little rhyme or reason to them. But subject access requests are often made by disgruntled employees. If there's any kind of disciplinary process, we often see those two things go hand in hand. And any kind of dissatisfied individual, so any kind of beneficiary or service user who's not happy with something that you've done or a decision that you've made, then they will sometimes use a subject access request, and they will use it in one of two ways: either because they genuinely want some information that they think is going to help them mount some sort of campaign or take some sort of legal action, or they do it because they know that subject access requests are resource intensive and they want to annoy you. And unfortunately, that is something that people do. And there is no, unless you can demonstrate clearly that the individual has no real intention to look at the information, they don't actually want it, it's very difficult to refuse to deal with them. So generally speaking, even if you are 90% certain that the individual who's made this request doesn't care about the information and isn't interested, unless you can prove that in some way, you will end up having to deal with it either now or at the point where they complain to the ICO and the ICO tells you you've got to deal with it. So you get a subject access request, and the starting point is around the searches. So your obligation is to carry out a reasonable search for the information that they have requested. And some individuals will say, I want to see everything. And some individuals will say, I want to see everything that relates to X, or I want you to search someone's inbox for all the information that they've sent that relates to me. Some will be very specific, some will be very wide. What we quite often see, and there is a template floating around out there somewhere that people are using, where the individual will specify what they want you to search. And I always say to clients, yeah, that's nice, but it's not their right to tell you how to carry out your search. You can frankly ignore that and just carry out what you think is a reasonable search. So for example, if you had let's say you've got a disgruntled employee by the name of Andrew Tanner, and he makes a request for all the information you hold about him, and he wants you to search for Andrew Tanner, Andrew Tanner, and AT, his initials. Now, obviously, if you do any kind of search for AT, I think you'd pretty much pull up every document you'd ever created or every email that had ever been written within your organisation. That is not a reasonable search because that doesn't enable you to identify Andrew Tanner's personal data. If you're a large organisation, you may have 3 employees called Andrew and, say, 17 beneficiaries called Andrew. So again, even searching for Andrew won't locate Andrew Tanner's personal data. It will locate a huge wealth of irrelevant personal data. So you are entitled in that sort of situation to ask the individual for more information to be able to narrow down the search and to carry out a reasonable search. Now, as I mentioned before, subject access requests are quite often used as a weapon. Or they are used in the process of trying to get information to support a complaint, etc. So in most cases, you will probably know what it is the individual is trying to get from you or what they're trying to get hold of. So if you've got an employee who's just been through a disciplinary process, they are likely to just want the information that relates to that process. They're not likely to want all the emails they sent in 2004 telling you they weren't going to be in because they had a cold or they had the flu or whatever it was. So you usually have a fair idea of what they're wanting. So what we usually suggest is if you're going back to ask them to narrow down their request, we would suggest giving them some suggestions or indicators. And this means you get to cherry pick the information that you know is easily accessible and won't produce vast amounts of results. So you can narrow it down. Of course, they've got the right to come back and say, no, I want X, Y, and Z. But actually, if they don't really know what they want, if you suggest some categories, then quite often we see requesters say, yeah, okay, I'd like that, please. And also you can make the point that it's always open to them. Once they get that information, they can make a further request if there's something in there that they think they need. Once they've got that, they haven't got X, so they can make that request. And in the case of a grievance, we often include things like personnel files because they are easily locatable because they're usually in one place. Most of the information will just relate to that individual, so you can just send it without having to go through it in any real detail. So that's really helpful. So absolutely fine to ask the requester to narrow their request. And actually the time limit, you all know that you've got a month to deal with the subject access request. The time limit pauses if you're asking for clarification. So if the requester knows this, they will come back to you straight away. I have seen that within an hour of sending an email, which is very frustrating. But some of them will take it away and think about it, and then you've got an extra week to start collecting this information. If you do have Andrew Tanner and he refuses to narrow his request, then you can narrow it however you want. So you would need to think about, okay, how can we carry out a search to only identify Andrew Tanner's data, but make sure we get most, if not all, of it. So for example, searching for Andrew Tanner, just Andrew Tanner, won't give you all of his information because I would expect that when there were email discussions going on, he would be referred to as Andrew. If he's referred to as Andy and nobody else is, well, great, you can search for Andy. And it's difficult for me to I often get asked in this kind of context, well, okay, but how do we do that? I can't tell you because one, I don't know your systems, and everyone's system is different, and the way that it's searchable is different. And secondly, it helps to have the context. So it helps to know specifically who's asked for it, what their name is, what the issue is with what you're pulling out, and how all of that works. So it's very difficult for me to answer a generic question, but if you ever do have a specific question, of course, do please get in touch and I'll do my best to help you refine your searches. The second area that comes up a lot is around third-party data. So when someone makes a subject access request, the starting point is they are only entitled to their own information and not that of any other person. So I'm going to use Andrew Tanner now throughout this as my person. It's a fictional person. I don't actually know anyone called Andrew Tanner, but he had sensible, useful initials for me to illustrate my previous point. So we're looking for Andrew Tanner's personal data, and there's an email from the head of HR to various managers saying these individuals have not had a performance review, and it lists all of the individuals that haven't had the performance review. Now, Andrew Tanner is only entitled to know that he was on that email. He's not entitled to the other names. So you just take those out. And how you take them out is up to you. If you're going to redact it, as in black it out, we recommend using software because, as I know from having done this for a very long time, so before software was able to redact documents, if you're doing it with a paper copy and a black pen, you have to go over it and you have to hold it up to the light and then you have to go over it again and then you have to photocopy it and then you have to go over it again, and it takes a good 3 or 4 sessions to actually properly obscure other people's information. So if you're redacting, we recommend software. If you don't have software, then you can extract the information. So there's no entitlement to the document itself, it's only the information. So you can just say there was an email between the head of HR and all the department managers, which listed you as not having had a performance appraisal on this date. And that's fine because that is the information. So you don't have to give him a copy of the document. So that is third-party data. But there is 2 types of third-party data. There's third-party data that is easy to redact, like I've just described, so you can just take it out and that's fine. But there's also a category of third-party data that is known as mixed personal data. And that is where it's not possible to take Andrew's data away from the other person's data. And a classic example of this is in relation to an employee grievance, where you have an employee, so Andrew, for example, someone has made a complaint about him and they've sent in an email saying Andrew was rude to a customer on this date, rude to a beneficiary. He used this kind of language and it was very inappropriate. Now, if that was in a situation where the only people who were in the room at the time were Andrew, the other employee, and the beneficiary, Andrew will know, even if you take the names out of that description, Andrew will know exactly who's written it because it can only be one other person. So that is known as mixed personal data because you can't extract the information about Andrew's behaviour without also identifying the person who brought that to your attention. So where you've got mixed personal data, you only have to release that if you have the consent of the employee, in this case, of the third party, or if asking for consent is unreasonable or you don't have that consent, it's reasonable in all the circumstances to release that information. Now, if Andrew Tanner knows that this person has made the complaint because they talked about it and you know that they know, and the other person is quite relaxed about it and has told everybody that they've made this complaint, then possibly it is reasonable in all the circumstances to release that. If the complaint was clearly made in circumstances where that employee thought you were going to keep that confidential and not share it with Andrew Tanner, then it would not be reasonable in all the circumstances. And it's probably not reasonable to go and ask for consent in those circumstances either, if you already know. And the reason I've brought this up is that it's really important to understand that personal data is more than just a name. So it is anything that can identify an individual. And sometimes, even if you just take out a name, you can still identify an individual from what's left. And I had an interesting situation with a client recently with this, where two ex-employees had made subject access requests. There was no issue around, it wasn't a grievance or anything. We weren't entirely sure why they'd made the request, but they'd made the requests for similar information. And both of them, one of them had said, I am going to speak to the other person on Tuesday, and we're going to go through the results of our subject access request together. So they were going to compare notes. So they knew this. Excuse me. Within the subject access request information that they were going to disclose was a log of an incident where both individuals were late for work, and they'd caused some other, I can't remember what the details were, but they'd caused some other problem. Both of them were involved, and it was a log of the incident. So the person writing it wasn't necessarily identifiable because they were just stating some facts that had happened. But the two individuals involved were identifiable to each other because they were there at the time, and they both knew that they were both late, and they were going to discuss this together anyway. What the client did was they, as a matter of course, they took out all third-party names. So they didn't stop and think, one, is this third-party data, and is it reasonable, and is it mixed, or all of those things. They just, which I understand because subject access requests are resource intensive, so anything you can do to make the process quicker, completely understand. So they took out the names. Of course, what they then did was accidentally sent an unredacted version of that particular report to one of the individuals. So one had the other girl's names blocked out, and the other one had the names in. Now, legally speaking, there is nothing wrong with the unredacted version. It is mixed personal data, absolutely, but it was reasonable in all the circumstances to release it. And actually, even with the names redacted, the individuals knew who that other person was. So they were still identifiable, even if you took the names out. Of course, the individual claimed data breach. And they wrote a letter initially and said, there's been a data breach, you need to resolve it. That's where I became involved, and I wrote and drafted a nice response back that said, actually, it's not, because it's a policy that we apply in order to take the names out, but actually the other person was identifiable to you anyway. There's no harm or prejudice or anything involved here, so there is no breach. They then went away and employed a solicitor to write an incredibly lengthy letter in relation to this alleged data breach, which contained all kinds of information, all kinds of alleged breaches, and even include a breach of the Treaty for the Establishment of the European Union. Pretty sure that doesn't apply now we're out, but even if we were in, I don't think it would actually apply to organisations. But anyway, that was thrown in there. And it ended up costing the client £3,500 just to deal with this ridiculous data breach claim, which actually could have been avoided if they'd actually applied the mixed personal data exemption properly in the first place. So it's so important. Again, it's a bit like privacy notices. I know it's difficult and I know it's a pain, but if you try and get it right first time, it can save you a lot of money in the future. The other common pitfall I see in relation to subject access request is not providing a valid covering letter. And again, this is not a major breach, and it won't involve you getting fines. It's just something else that the individual can use to complain about. So if I make a subject access request, I'm entitled to see the personal data that is held about me, but I'm also entitled to know information about that personal data. For example, I'm entitled to know why the organisation has my data, who they sent it to, whether it's been sent outside of the UK or the European Economic Area. And these things should start to sound familiar if you've read the list of the information that you have to provide in your privacy notice. And so, in a nice little linkage, if you have a brilliant privacy notice that contains all of the information that it should contain, you can send that with the data when you're responding to a subject access request, and that pretty much, there's a couple of tweaks, but it pretty much covers what you are required to provide. So you don't have to reproduce an additional covering letter. You can actually potentially use your privacy notice, and you will have complied with your legal obligations, both in terms of your privacy notice, but also in terms of responding to the subject access request. Right, data breaches. The majority of data breaches that I see and that we see in the firm are human error. And that is something that, first of all, you cannot prevent because we are all human and we all make mistakes. So it is not possible to stop all data breaches. And if they are caused by human error, provided it's once, that's okay. Nothing bad is going to happen as a result of that in terms of the organisation being fined. Yes, the individual may need speaking to, they may need additional training or whatever, but it happens to us all. And the first thing I usually say when I have a client on the phone and their poor administrator has sent an email and they've not BCC'd or whatever they've done is, yeah, it happens to us all. It has happened to me. I have sent an email to the wrong person. And I'm a data protection lawyer, so by nature I'm paranoid and quite careful. But we all have days when we're more tired or whatever. It happens to everyone. Before you get to the point of a data breach, really important that you keep your training up to date and you keep a record. So you've all attended this training today. You need to make sure that somewhere in your organisation there is a record that you've attended this training, because if you commit a data breach, although this training isn't specifically about data breaches, but one of the first things the ICO will say to you is, has the individual who caused the breach been trained? And when were they last trained? And what were they trained on? So it's really important to keep a record. And quite often, for example, at VWV, when at the very beginning of the pandemic, when we were all working from home and there was a surge in cyber attacks, we had a regular, I think it was weekly, standing agenda item on our team meetings about cybersecurity, and it was a reminder to not click on links, etc., all the standard stuff. But that is logged so that we know that we have all been trained or made aware of that. So it's important to log that. If you've had a data breach and you're not sure if it actually meets the threshold for reporting, do call the ICO, because they are actually very helpful. And in fact, I mean, it depends who you get, obviously, but I've actually had a yes no answer from them twice before when I phoned up on a no names basis. So if it's clearly yes you should or no you shouldn't, they will actually tell you that. And if it's borderline, then they'll probably just tell you it's borderline and to go away and think about it. But do call them, and it's not going to count against you if you phone them to get more information. And obviously, when you're a charity and you're regulated by the Charity Commission, don't forget that you might have to also put in a serious incident report. And the flip side is true. If you're putting in a serious incident report that involves a data breach, have you notified the ICO, or have you decided you don't need to? Because regulators do talk. Not as much as they probably should, but they do talk. And if one becomes aware of an incident that's been reported that the other one's not aware of, then they're immediately going to be asking you those questions. And similarly, like with serious incident reports, if you're fairly sure that this is going to go public, I would report it to the ICO whether you think it's reportable or not, just so that they're aware. And you can always just contact them and say, we've had this issue, we're dealing with it, we don't think it's reportable, but be aware, so they don't read about it in the press and then come asking the questions. They already know about it. And as with the Charity Commission, that can be really helpful. Other common pitfalls that I see in relation to contracts, and this is something that comes up time and time again, and it is complex, and I do appreciate that, but I will urge you all to get advice if you need it. So if you are engaging a data processor, so someone you are engaging to do something with personal data on your behalf, and they are not a data controller, so they are not deciding what they want to do with the data, they don't own the data, they're just carrying out a service for you, they are likely to be a data processor. And if they are a data processor, there is a legal requirement on both of you, actually, it's not just on the controller, it's on both of you to have an agreement in place, a written enforceable agreement that contains specific clauses. So I've listed there on the slide, if somebody is a third party, so not somebody who's already employed by your organisation, a third party using your personal data under your instructions, they don't own the data and you don't want them to take it away when they've finished whatever they're doing, they are probably a data processor. And the key there is to make sure that your agreement is compliant. And what I quite often see, and as a lawyer, and as you might expect, a little bit of a pedant because of what I do, really frustrates me when I see agreements that are almost compliant. So they contain 90% of the clauses, but they've missed one out or they've missed a couple out. And you think, if you're going to do this, do it properly and make sure that it's fully compliant. The risk, if you are the controller and you don't have a compliant agreement in place, in all seriousness, the risk is that if there is a breach by the data processor, you could end up financially responsible to the individuals for that breach. So that's why it's important to have an agreement in place. There are lots of different variables which will affect whether or not that ends up being the case, whether you are financially liable, but one of those is whether or not you have this agreement in place. So it's really important risk-wise to make sure that you do have that in place. Most organizations you're working with, if you're working with larger organizations who know their stuff, they will know that they're a processor and this shouldn't be a surprise to them, and they should be happy to sign up to provisions. There may be some negotiation around who pays for what or whatever, but there's a core set of provisions that they have to comply with and that should be in the agreement. So they shouldn't have a problem with signing up to them, and if they do, perhaps they're not the type of organization that you will want to get into bed with. The other issue with data processor contracts that comes up, I was talking earlier about mergers, and obviously in the current climate, we're seeing lots more organisations sort of working more closely together because of the issues with resources and funding, etc. If you do merge and you do some due diligence, one of the standard questions is, who are your data processors and are all your agreements compliant? And if you don't know who they are, you can't say whether the agreement's compliant, and then you have to pay someone like me to trawl through all your agreements, try and work out whether they are or they aren't processors. And once I've decided they are a processor, then I have to look and see if all the current clauses are in place. And that takes a lot of time, and to be honest, is one of the least interesting bits of my job. So I'd rather not do it. I'd rather it not cost you that huge amount of money. So I'd rather you did a bit of due diligence yourself to start with before you get to that point. So you know who your processors are, and you know that you've got compliant agreements in place. So to finish off, just a few practical tips to aid compliance. Keep records of how you're complying, and keep reasons and notes of reasons for decisions that you make in relation to data. Now, as a data protection lawyer, I always feel slightly nervous about saying to my clients, create more information, but that's what I'm asking you to do here. So if you don't keep records and you don't keep notes of decisions, if you have a discussion about something and then you don't note it down, when the individual complains 6 months later, you won't remember why you made that decision necessarily, or you won't remember all of the factors that you took into account. So it's really helpful. And the records of how you're complying. So I mentioned with training, just having that kind of centralized note somewhere that shows that you do comply, and then you can demonstrate it easily because you've already got that information in one place. I always bang on about this as well. Delete what you don't need. If you've got information that you're not using, you have no intention of using, get rid of it. And that applies to historic information, but also emails. You really don't need emails hanging around for ages and ages. I've had a really busy few weeks. My inbox is currently around 150 emails. That is stressing me out as we speak, because I usually have 5 or 6 in there. Because as soon as I've dealt with something, I mean, we store them on our system, but it's either allocated to a client or it's gone. So the email I had this morning about did I want to contribute to a colleague's leaving gift, as soon as I'd made the contribution, obviously, as soon as I'd made that, I deleted the email. I don't need it anymore. And it's really important to speak to your staff, your volunteers, whoever it is who's working on your system, and make sure they understand the importance of getting rid of stuff you don't need, because it inevitably comes back to bite you when you have a subject access request and someone's kept that email where they called Andrew Tanner a moron 6 months ago. Whereas if they just deleted that, it wouldn't be on the system, you wouldn't have to release it. And also, my final tip is around not only speaking to staff about cyber threats, phishing, the dangers of using your own devices and all of those things, but making sure they understand why. And the reason I say that is because I don't know how many conversations with, I have quite a lot of my family and friends are teachers. And when the pandemic hit and they were working from home and they were working from devices, etc., I had so many conversations about, well, my organisation is saying I have to do X, Y, and Z, and that's just ridiculous because it makes my life more difficult. Da, da, da. And I had to say, yes, but the reason for that is, and I would explain that there's a safeguarding reason, or there's a cybersecurity reason, or there's a reason why you have to keep changing your password, and it's really important. And once I explained those reasons, they were much more accepting, and appreciate the pandemic is not a good example because everyone was just panicking and trying to get things set up and done and etc. But we're not in that situation now. So now you're getting hopefully back to a bit of normality. When you are talking to staff about these things, give them the context as well as the direction. So if the direction is don't use your own devices, you can give them a bit of context about that and say, well, because if someone makes a subject access request, for example, we might have to ask you to search your device for that information. And we don't want to do that because it's your personal device. It's not as secure, inevitably. I'm a data protection lawyer. I will hold my hand up. My personal phone is nowhere near as secure as my work phone because there is stuff on my work phone that I could get sacked if that was compromised. My personal phone, that's my issue if somebody hacks into my bank account, but it doesn't relate to work. So people are genuinely a lot more careful with work than they are in their personal lives and all of those things. I have talked for far too long at you now, so I'm going to pass over to Amy and she's going to read through some of the questions and then I will do my best to answer them. And if I can't answer it, I will be honest and we'll follow up with you afterwards.
Great, thanks, Vicky. So we've got quite a few questions in. To mitigate against multiple amendments / mini privacy notices, is it better to be broader in what we include / gain consent for, or does this prevent us being explicit and transparent about data use?
There is definitely a balance to be struck there. So it's different in terms of what you have to provide under the privacy notice and what you have to get consent for. So the consent does need to be informed. So that needs to be more granular. So I think I would always advise against getting general consent because then you end up with consent for nothing rather than consent for the things that you actually want. But in terms of your privacy notice, yes, it's fine to generalize up to a point. But I think that's one of those questions where I'd probably have to have a question about context because it's difficult to advise sort of out of context on that.
Brilliant, thank you. If we ask a subject for clarification or to narrow the scope and they simply do not respond, how long should we wait before carrying out the searches, if at all? Also, if we do not have enough information, so cannot carry out the request, should this simply be logged as an incomplete request?
That's a very good question. And so what I would recommend when you send out your request for clarification, you put a deadline on it and you say, if we do not hear from you by whatever date, either we will collect the information. If you've suggested some categories, I'd say If we don't hear from you within 2 weeks, we will begin to compile the information above, and we'll presume you're happy with that. If actually you've got no idea what the person wants and you can't narrow the categories down, then if you don't reply within 2 weeks, then we will be unable to deal with your request, and that's fine. And the second part of that question was about, sorry, just read the second part again, Amy, so that I get it right and I don't answer the wrong
No problem.
thing.
Also, if we do not have enough information, so cannot carry out the request, should this simply be logged as an incomplete request?
Yes, yeah, that's absolutely right. So you have to tell the individual that you're not complying with their request, and still invite them to go to the ICO if they want, but that's up to them. But yeah, if you don't have enough information to carry out a search, then it's not a valid request.
Brilliant. And what criteria make an ICO report relevant to report to the Charity Commission?
If you have reported a breach to the ICO, as far I'm not an expert on what the threshold is for serious incident reports, but we generally work on the principle that if you've reported to the ICO a data breach, you will report that to the Charity Commission as a matter of course, because there are usually potentially reputational issues that will tip you into the threshold for serious incident reporting. And I think the same is probably true the other way. The criteria for reporting a breach, you have to report it unless there is no impact on individuals. So I think if there's going to be an impact on individuals, then you would automatically report to the Charity Commission.
Great. I've got a bit of a long one here. The impact of the pandemic has meant we have far more of our staff working from home, meaning that households potentially have access to personal data our company holds that wouldn't have before working from home directives. Can you recommend any resources to help charities like us train slash advise slash guide our staff to observe GDPR safe practices at home?
That is a good question. I'm trying to think what resources I can. We have a working from home policy that is not called that. I think it's called COVID policy or something like that. That sets out the rules or some suggested rules around working from home. Um, Off the top of my head, I can't think of any resources that you might be able. The ICO website has some information about COVID and home working, so that's probably the best place to start. And then actually, because there aren't any, so the GDPR generally says you must keep data safe, but it doesn't actually tell you how you have to do that. So how you do it is up to you. So the best place to start may be to sit down and write out a list of the things that you want your staff to do, and then you can develop that into a policy. So for example, you expect them to not leave notebooks out on the table where they can be accessible. They make sure that their computer has a password that only they know, and those sort of basic, they sound basic, but they're not when you're start working from home. But those kinds of things that you want to tell staff.
Great, thank you. Would a situation where payroll information is outsourced to a second company to make the payments to staff be an example of a data processor relationship?
Yes, it absolutely would. So that's the classic example of a data processor. The other classic example is your whatever system you use for your computers. So whether you're using Microsoft and Teams, etc., whether you're using Google, they are also a processor because you're chucking personal data in there, but you don't actually. Microsoft has no right to use the personal data in your emails for their own purpose, for example. So they're a data processor, but you will have signed up to their data processing terms at some point, because they incorporate that as part of their sign up process. But yeah, payroll, cloud service providers, those are the two sort of key examples.
Brilliant. If social services refer a beneficiary to us, they will say that they are the data controller. but when the individual becomes a beneficiary of ours, we would class ourselves as the data controller. Is this correct? And if so, who is responsible for drafting a sharing data agreement?
Um, I would say, yeah, in that case, you're definitely both controllers, because social services are not going to dictate to you what you then do. You will make your own assessment, presumably, and deal with the beneficiary how you need to deal with them. And you'll decide what information you want and where you store it and all of those things. So there is no legal requirement to have a data sharing agreement in place in that circumstance. However, it can be helpful. Because there's no legal requirement to have it, the responsibility doesn't sit with either of you. One of you can suggest it and the other one can go along with it. That's absolutely fine. But if it is pure controller to controller sharing, there's no legal requirement there.
Great. When you say get rid of emails and data you don't need, I have struggled to find a categoric list for retention timelines for data relating to an educational charity in Scotland. Are you able to advise where to find robust and practical retention timescales?
The Institute of Records Management, they used to be irm.org.uk, I think, but they may have changed the name since. They have a they used to have a retention schedule for schools, which is probably the best place to start. I don't know whether that is just England and Wales, though, or whether that would extend to Scotland. So it'd be worth having a look. But I don't, off the top of my head, I don't know where the best resource would be for Scotland. I can ask, though. I will log that question and see if I can find something for you. Just going to write that down before I forget.
No problem.
Brilliant.
Okay. Have you ever had issues with trustees who are volunteers and who use their own devices / email accounts?
Yes. This is a really difficult. It's not a really difficult position. It's awkward, because in a lot of cases, most charities can't necessarily afford to issue trustees with trustee only email addresses. So the ones that end in the at whatever your organisation is. And even if you do, you will get trustees that will complain about that and say, "Oh, I don't want to be checking lots of emails," and all of those things. The main issues that arise there are trustees not understanding necessarily that just because they're using their personal device doesn't make it a personal communication. So it's important to, if trustees are using their personal email addresses and their own devices for trust or charity business, that's not a breach of the GDPR, but it's more about the trustees understanding that if you get a subject access request, then that information is owned by the charity and not them, so they are obliged to hand it over essentially. So as long as they understand that, that's fine. And what we would say is, when ideally give everyone a charity email address. If you can't do that, you need to assess the risk. So what information are they actually accessing? If it's only minutes of meetings, so I'm a governor of a school. They use my personal email address, but for distribution of what's generally working out when we're going to have a committee meeting, because everyone's so busy and we're trying to fit it in. That's not personal data, so it doesn't matter. All of the papers, etc., go through a secure portal, so I'm not actually getting personal data from the school on my personal mobile, so that's fine. The risk there is really low. So I think it's about making sure trustees understand the consequences of what they're doing, but also assessing the risk. And if you are a high risk organisation and you're transferring lots of sensitive information on a regular basis and you don't know where it's being stored, etc., then maybe think about whether that's charity email addresses are an option.
Brilliant. I think we've probably got time for another few questions. Can we include our privacy notice on our website, or do we have to provide each of our clients slash individuals with them?
That is a good question. You have to show that you've provided the information. So if you put it on your website and you never refer to it again, that's probably not enough. Um, but at the same time, you also don't have to necessarily send it out to everybody by email every 2 years. As I've heard, some organisations do that, and they need to do that, and that's great. What we quite often see, and what seems to work as a halfway house, is at some point you tell the individual, by the way, our privacy notice is available on the website, and if you're corresponding by email, you can just send them the link, and then they can choose to go and read it. Obviously they won't, because nobody except data protection lawyers ever reads privacy notices or complainants, but yeah, some kind of, as long as you've got some kind of audit trail that shows that you've made an effort to draw that to their attention, that's fine.
Great, and we probably have time for another one or two questions. If we require information in order for someone to use our service rather than consent, what would be the appropriate justification for collecting the data?
That is, if you don't have any sort of formal contract with the individual, then it's probably legitimate interests. Um, Depends exactly what you're doing, because there are two sort of options. There's public task in the public interest. So if you're doing something like education related, that generally falls into a public task in the public interest. Whereas if it's less public-y than that, then legitimate interest would be fine. And actually, if an individual is benefiting from your service, if they give you the information, then that balancing exercise is really easy, because the legitimate interest is for you to provide the service, it's for them to receive the service, and the prejudice to them is zero, because they are receiving the service that they need. So yeah, legitimate interest is probably the one to go with.
Okay, I think we've probably got time for one more question. Can we have more than one lawful basis for a single service? For example, for our monthly newsletter, can we rely on legitimate interest for some of the subscribers and consent for other subscribers?
Um, so theoretically, yes, you can have more than one lawful basis. And actually, the ICO advice has always been choose one and stick to it. My advice has always been choose as many as you can, because if the ICO happened to find that one didn't apply, then you've got others in the backup. So yeah, absolutely, you can have more than one legal basis. With marketing, that's obviously made more complicated because you're not just looking at the data protection regulations, then you're also looking at the privacy and electronic communication regulations. So if you're sending things out by email and you're marketing, then PECA potentially apply, and they may require you to have consent. If you've got to have consent for PECA purposes, then you may as well have consent for GDPR purposes, because it's the same. So that's fine. If you've got consent anyway, you've got consent. But yeah, there is, so potentially there's nothing wrong with having two legal bases, or three or four, if you can find four that fit.